This is case number CR 19-1821A and case number CR 1821B. Appearances, please. We'll start with the plaintiff.
Chris Day on behalf of the state. And
Mr. Day, have you received the notices?
I apologize. Yes, I'm appearing from Reno, Washoe County, Nevada. I've received all the required notices and I have no objection to proceeding at this time.
Very good. Thank you. For the defense.
Good morning, Your Honor. Ken Lyon, appearing from Reno, Nevada, on behalf of defendant Michael Schneider. I've received all the relevant notices and have no objection going forward this morning.
Good morning, Your Honor. David Houston on behalf of defendant Leilani Schneider. I am from Reno, Washoe County, Nevada, as far as proceeding and where I am located. My client is also located in my office, as is the co-defendant Michael Schneider. I'm familiar with the rules and have no objection to proceeding in this fashion. And I wanted the court to know both defendants are seated immediately to my right. And if the court would prefer, we can have them step into the camera and then be reseated, social distancing away where they are currently.
Yes, I would. Thank you.
Can you step up so the court can see you?
Thank you very much.
Thank you, Your Honor.
They may resume. I guess you had a conflict this morning, Mr. Houston, in Department 4.
Yes, Your Honor. I was with Judge Steinheimer, who was kind enough to advise me that under the administrative rules, I wasn't leaving her department until I was finished.
I just was unaware because you had actually ended the stipulation to have it continue to today's date at 10.
Correct.
I received word that happened.
I thought this
All right.
was being continued as well, and the state last night advised me they could no longer stipulate.
I beg your pardon?
I thought this morning's in Department 4 was going to be continued as well, and the state advised me by email last night that they could no longer stipulate to continue that hearing. Otherwise, I would have
Okay.
been.
I just needed to have the record be made while we were starting when we did. Thank you. This is the time set for pretrial motions. I had previously ordered pretrial motions to be set in November. There was a stipulation to continue with today's date. I've received the pretrial motions in this matter. The trial in this case is scheduled for March 8th, 2021 on the trial flight 7. The motion to confirm date is February 17th. Under the circumstances and pursuant to our administrative order that was filed September 14th, 2020, known as Administrative Order 2020-02E. The last date for pretrial motions would be on January 20th. So I have the motions here now that you've filed. Some have been filed by your representation, gentlemen for the defense, and some have been adopted by reference from the previous lawyers for the defense. I've reviewed them all and I'm prepared to proceed. I don't really have a particular order that I care for. I certainly can call them out. I can start with the defense motions, of course. Was there a particular one you want to start with, Mr. Houston or Mr. Lyon?
Your Honor, we might be able to streamline this a little bit as well, in that there's a couple of motions that are not opposed. The two motions that I have, we had filed a motion in limine to preclude testimony concerning disaffected customers, and the state filed a non-opposition to that one. So we would ask that that be granted. Similarly, we had filed a motion for equal access to juror information, and the state filed a non-opposition to that motion. So we would ask that that be granted. There were dueling motions regarding prior bad acts or other act evidence. The defense had originally filed a motion to eliminate more of a prophylactic motion to preclude prior bad acts. In response, the state had filed its motion to admit other act evidence, which we filed an opposition on Friday. However, in speaking with the clients, we are prepared to withdraw our opposition to that motion, which would, as I understand it, involves a 2013 citation that was issued against Mr. Schneider. There would be, I think, with the admission of that evidence, the need for a limiting instruction given that Leilani Schneider is a co-defendant in this case, to cure any potential prejudice of that evidence as it may pertain to her charges. But we think we can address that at the time of trial. And I think by withdrawing that motion or our opposition to that motion, that'll significantly streamline the matters here this morning, and we will not need to take any testimony.
I'll say, first of all, I'm going to grant the motions for joint equal access to jury information and the motion for disaffected customers. I did note they were unopposed. Thank you for once again emphasizing that to me, Mr. Lyon. I'm going to allow the other act evidence without a hearing based upon your withdrawal of your opposition related to the 2013 citation. We'll see how that comes into play at time of trial and how that's used by the state. It does not eliminate or foreclose additional objections from the defense, depending on how it's used, but for the purposes of not requiring an evidentiary hearing today, it'll be admitted for purposes of Mr. Day's preparation for trial. And thank you for that. Put those over here. Then I have, were you, other than your generic motion for prior bad acts, was there anything in specific you had in mind, or you were just protecting the record with that motion?
Just protecting the record. And
thank you. Thank you. I have the joint motion filed by prior counsel for a motion in limine related to Dr. Jose Fernandez Cruz. Is that still alive?
Yes, Your Honors, and we could probably take both that motion and a similar motion in limine regarding Dr. Maureen Adams. Those were two prior veterinarians that worked with Puppies Plus and Puppy Love, and we anticipate that those two veterinarians will be called to testify at the time of trial. Each veterinarian has had issues concerning their past and their licensure with the Board of Veterinarian Medicine. With respect to Dr. Cruz, he had some prior DUIs out of California that impacted his ability to be, impacted his application to be licensed in the state of California. Prior counsel had moved to exclude that or prohibit the state from impeaching Dr. Cruz on that, in that it is irrelevant to the issues presented in this case, primarily that any issues concerning his DUI convictions and how that may have impacted his licensure really has no bearing. He was a licensed veterinarian at the time he worked with Puppies Plus and Puppies Love, and therefore it's really irrelevant to anything concerning impeachment, which would involve credibility, bias, opportunity to observe, those sorts of things that the state has raised. Dr. Maureen Adams is similar. She had some prior alcohol issues and or drug issues. We're somewhat in the dark on that. The state has not provided any discovery concerning potential impeachment information concerning Dr. Adams. So we're just going off, and I haven't been able to find any, so we're just going off prior counsel's representations. Similar arguments, we believe it's irrelevant. The state argues that both doctors were their license were suspended, and that's the relevancy that the state hangs its hat on. I don't see any issue, any proof that the license were actually suspended. At least with Dr. Cruz, it was just they had initially denied his application. They entered into an agreement that should he do certain things, then he would be allowed to move forward with his application and vet licensing. So I think that is a distinction that we would ask the court to look at in looking at the relevancy of that information for impeachment purposes.
Mr. Day.
Thank you, Your Honor. So it's, you know, they're similar, I think, in both cases. But you know, essentially, one of the state's theory of of our case here is that the Schneiders these two defendants had ample opportunity to get the services of veterinarians in this community, and over multiple years procured the services of vets, one out of California who had issues with his license, and a second in this community, and that was the real onset of this case in a lot of ways, in Dr. Adams. And I struggle with this because, frankly, I agree with almost everything that was just said. I don't want to admit at trial issues with Dr. Cruz or Dr. Adams' license as far as why they were suspended, and I don't know how to thread that needle, and I'm not seeking to put them on trial in any way, and so I struggle with that, and frankly I don't know how to thread that needle other than to say I think that the issue of the fact that both of these vets that these defendants used had their license at issue, I think that's relevant, but I beyond that, I do struggle with that, Your Honor. So
I understand. Briefly, did you want to reply at all, Mr. Lyon?
No, Your Honor, we'll leave it.
Did you want to reply, Mr. Houston, in any manner?
No, Your Honor.
Thank you. So I understand the issue. So I'm going to help you thread the needle. Number one, you may not introduce any evidence of any type of underlying offense. DUIs are irrelevant if that was the case. You'll make a decision strategically when you hear their testimony whether or not you need to say, for an example, isn't it true that you had your license suspended? And if they had their license suspended for acting as a veterinarian, I'll make a decision outside the presence of the jury whether I'm going to let you ask them, isn't it true you had your license suspended, based on what you're trying to utilize. You may not want to impeach them at all, depending on their testimony. But that's how you can thread the needle, is to use your expression, is the underlying offenses won't be allowed. They're irrelevant legally and factually. However, if there's a witness that is opining based on their veterinarian expertise, and you find it relevant to bring up the fact that you can impeach their veterinarian expertise by the fact that they have been suspended, not suspicion of suspended, not have to do certain things to get their license back or qualify to be a veterinarian in California. That's not what I'm talking about. If you have a valid suspension, that goes to impeachment based upon their credibility of being an expert witness. I will allow that outside the presence after you make your proffer as to why you need it. All right? That's my order on that. What would be the next motion?
Your Honor, we also have a joint motion in limine to preclude the state's use of what we refer to as prejudicial characterizations.
Yeah, see that.
Your Honor,
Go ahead.
Thank you. Your Honor, in reviewing the state's opposition, it seems, again, we agree on most of these. I think, as the court is aware from the motion, we were concerned as to the use of certain, what we refer to as irrelevant and very disparaging terms, such as puppy mill, little pet shop of horrors, and things of that ilk. And the state, in their response, has agreed not to refer to the animals as victims, and also agrees that they will not be attempting to use the characterizations that we have objected to. Now, clearly, we can't list, by way of imagination, all of the derogatory reference points that could be made as far as language either used by the state or the state's witnesses. But based upon their opposition, it certainly seems as though they understand the concept, and as a consequence, I believe in some ways are stipulating to our request that these terms not be employed. There was also a discussion referencing this issue of breeders and the sourcing of puppies. And as the court is aware from our motion, we felt it would be prejudicial to allow the state to attempt to expand its case by presenting evidence concerning the sourcing of puppies, the defendants sold, or the impact of pet stores on dog breeding in general. And simply put, we found evidence of that nature to be prejudicial. As a consequence, we would ask that that not be part of the case. And again, in reviewing the state's pleading, it seems as though they referred to that as the equivalent of going down the rabbit hole. So my suggestion, by virtue of their response, is they're not planning to do so. And what I'm doing now, I guess, is simply achieving confirmation of that. The final issue was referring to the animal as a victim. As previously stated, the state has agreed they're not going to do that either. So all of that being said, I think we're as close to a stipulation on that as we could be. And certainly things may come up during the course of the trial that we did not list as potential disparaging remarks, comments, or characterizations, but certainly we can handle those at that time as long as we have the general premise concerning the trial that those sorts of statements are considered to be irrelevant and not to be used.
Thank you, Mr. Day.
Thank you, and I agree. I think we're in agreement with almost all these motions. I agree. I would not refer to any dogs or puppies as victims in this case. My only concern, and I didn't title it as a non-opposition for that reason, was the potential for a discussion about the origin of the dogs, and so I am uncomfortable in addressing some of this because some of these are charges that were not brought by the state, and they could have been. And frankly, this case was investigated for many years, and we thought about other charges. And so I don't want some of these issues to come forward at trial, and a lot of them relate to the origin of the dogs, and even the term puppy mill. I agree. I will not use that term at all during the trial, but some of the investigation in this case involved that. And so my only concern, I guess, is the possibility that the defendants would use would go, I guess, to use the term I use, rabbit hole, go down the rabbit hole of, we did everything in our best efforts to procure these dogs from the best possible sources, and maybe it was not true in essence. And that's, I just think that it could very easily go down a rabbit hole of where the dogs were procured from. And so again, I think, to me, this trial should be very fixated on the counts alleged in the indictment, but it could very easily go down a complicated and messy road, and that's all I want to avoid. So I agree. I think we're in agreement with everything else. I'm sorry, I'm fumbling for words, but I think we're honestly in agreement with everything.
Sure. I can always help you when you're fumbling for words too, because
I apologize.
I'll make the ultimate decision on the motion. So you're okay. I just want to know what your position was. Thank you, and you articulated it. Mr. Lyon or Mr. Houston, anything you want to add for reply?
No, Your Honor, I think the state's summarized it, and as a consequence, we would suggest we agree.
Very good. So this is my order. There's not going to be any derogatory language. I want everyone to know that should a witness say something that would be something not listed, a word, a verbiage, a reference, I'm not going to grant a mistrial based upon this motion. I will tell you that I'm ordering that the language or labeling that could be viewed as derogatory or prejudice will not be allowed. And of course, I expect timely objection from the defense if you think so. But I am understanding, I believe, what the state is saying. So I'm granting the defense motion that derogatory labeling will not be used. And that's my order. And of course, trials, different things happen in trial, but that's my order now for purposes of your preparation. What would be the next motion, Mr. Lyon or Mr. Houston?
Thank you, Honor. The only other outstanding motion that I have was a motion for discovery filed by prior counsel. We did meet with Mr. Day in reference to trying to work through this. There's issues about some illegible copies and other things from one of the veterinarians. To the extent that that stuff is going to be utilized at trial, I'm sure we can come to an agreement. The biggest issue that Mr. Houston and I saw with the outstanding motion was that there was a search warrant served in this matter. And as far as we've seen, the evidence that was seized at the time of the search warrant, particularly concerning the Cocker Spaniel, which is at issue in this case, has not been turned over to the defense. Honestly, I can't remember if we talked with Mr. Day about this and what his thoughts were, but I think with respect to the motion for discovery, this is something we can work out, but that was an issue we wanted to raise. And then just for the record, prior counsel had filed a motion to dismiss and a motion to file more motions, and we formally withdrew both of those just for the record.
I've heard of that motion to file more motions. Thank you. I note that I note they're withdrawn. I noted that previously, so thank you for making that record. Were there any other pretrial motions that anybody wants to make orally that have not been filed since this is the time set for the pretrial motion date that I haven't seen or reviewed? Anything from a housekeeping perspective? Let's start with the defense.
Nothing on behalf of the defendants, Your Honor.
Thank you. Mr. Day?
No, Your Honor.
All right, nothing from housekeeping. I'm going to set another status conference in this case for Wednesday, January 20th in the what I call my out of custody docket, which is at 1:30. And that would have been the date for the pretrial motions during COVID time. So if there's any additional, give you till January 20th to have them briefed and ready to go. But I mean, essentially, this was your date. But if you have anything else that comes up in the spirit of fairness, actually your deadline to have everything briefed for decision is January 20th. If you don't have anything in addition, we're going to use that as a status conference to see where we are. And frankly, take a look, see where we are in terms of jury trials in Washoe County based upon the pandemic caused by COVID-19. However, as we speak, you are on for trial on March 8th, 2021, with a motion to confirm on February 17th, and a status conference now that I've just set for Wednesday, January 20th at 1:30. Does anybody have any questions or anything to add that I've missed? Anything from the defense?
Nothing, Your Honor.
No, Your Honor, thank you.
Very good. Anything from the prosecution?
Your Honor, thank you.
Thank you very much for your time today. We'll be in recess. Thank you, everyone.